Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is avoiding malpractice claims. Speaking today will be Ron Collins. Ron Collins is an experienced attorney, a fellow of the College of Law Practice Management, and an internationally recognized author and speaker on the subject of law and technology. He is also the founder and CEO of Gavel & Gown Software, Inc., a company dedicated to providing practice management solutions that work the way lawyers do. The Industry Insight webinar series is hosted by the ABA Legal Technology Resource Center. To stay updated on upcoming webinars or view previous videos, visit ambar.org/industryinsight. You can also stay updated on legal technology news through our blog, www.lawtechnologytoday.org. Thank you all for joining us, and we'll now begin the webinar.
Thanks, Chelsea, and thank you everyone for joining me this afternoon. Delighted to be talking with you, but it's not a subject I really like, and I don't think it's a subject anyone really likes to talk about, malpractice claims. Face it, malpractice claims are just not fun. If you've ever had the misfortune to experience one, and I'm going to guess by the odds that at least half of you who are listening to me this afternoon have, you know that they can be distracting, tremendously time-consuming, and that's non-billable time-consuming. They're expensive to deal with, and even when you come out clean on the other side, the reputation issues and that little shadow lingers. Not to mention that your malpractice carrier can be increasing your premiums if you start to experience more than one, even if you're cleared of all of them. Malpractice claims are just something we all want to avoid if at all possible. So no, I'm not going to dig into all that bad news. That's the good news. What we're going to talk about is how to avoid them. Before we get into some of those techniques, let's just face some reality in terms of what's going on with malpractice claims out there today. The bad news is that they've gone up over 25% in the last 5 to 10 years. That's a significant increase in the number of former clients who are coming after their attorneys and saying, you owe me money, you didn't do it right. Not only is the number of claims keeping going up, but the complexity of those claims and the issues involved in them keeps getting higher every year, as are the defense costs. So resolving these claims is getting a lot more expensive than even it was 10 years ago, which gives us even more reason to want to not have them. We're all exposed to this. As attorneys, it's simply a reality. When we're in private practice, we know this is one of the risks of doing business. How bad are those risks? Well, the odds are up to about 17%. In any given year, you have about a 17% chance that somebody's going to bring a malpractice claim against you. Those are not great odds. Now, of course, there are some attorneys who never experience them, but out of any 5 lawyers, 4 of them are going to have at least one over their careers. And in fact, because some people have more than one, in fact, some people have a lot more than one, on average, you're going to have about 3 claims over the course of your career. Interestingly, most claims don't come up in the first few years of our careers. They tend to start around the 5th or 6th year of practice up to about the 25th year of practice, and then they tail off again. So the middle years of your practice, the productive years of your practice, that's when you're most likely to be having a malpractice claim to defend. Here's a fact that I find really interesting, and that is that small firms 2 to 10 are the primary area where malpractice claims arise. Solo attorneys, interestingly, are a little below average. There are 48% of attorneys out there, but only 34% of the malpractice claims, so they get less than their share. But attorneys in firms of 2 to 5 lawyers are the greatest risk, with almost double the expected rate. Because although there's only about 15% of attorneys in private practice in this segment, 32% of malpractice claims arise there. And then in the 6 to 10 range, it gets a bit better, but it's still more claims than on average occur in that segment. When you say, all right, but what area of law do I practice? Maybe there aren't a lot of claims in my area. real estate, a lot of people would have said is a relatively innocuous area. It can be routine. We know what we're doing there, and yet it is the single highest area today for malpractice claims, followed closely by plaintiff's litigation, especially in personal injury matter. Family law, there's no surprise there, but also corporate, estates and trusts, collection and bankruptcy. In other words, the full range of practice areas, those are the top 6, but the full range of practice areas experiences malpractice claims. And what are these claims all about? Well, the number one reason for malpractice claims today is all around client communications. Keeping your client informed, confirming and following their instructions, reporting to them after major steps or, of course, after end steps. Full and complete communications, if you like, being prepared to collaborate and share information all the way along the process, and of course tracking that is critically important to avoiding claims. Time management is the second biggest. So missing deadlines, missing statutes of limitation, procrastination, putting things off leads to a huge volume of malpractice claims. In fact, over half of all claims are in those 2 categories, client communications and time management. So those are areas we need to focus on if we're going to improve in this area. But there's lots of other areas like poor investigation or mistakes of law, clerical things like losing files, losing documents, and of course that thorny issue, conflicts of interest. Still 7 to 8% of all malpractice claims come because a conflict check wasn't done or wasn't properly done. So how are we going to confront that? How are we going to reduce our risk of having to face up to those claims? The short answer is there's technology available today that makes it really easy to significantly reduce those risks. And the technology I'm speaking about today is practice management software because it has so many capabilities for reducing the risks that give rise to malpractice claims. So we're going to now take a look at some practice management software, and we're going to take a look at those lists of issues we just went through and see how you can reduce the risk in a series of different issues. And I'm going to start that with tracking information. Of course, as attorneys, we tend to organize our practices around the files we open up for each client matter that we're working on. Tracking that information and keeping it consistent, available, making sure that the right information is tracked is tremendously important. Not losing those documents, having proper checklists, making sure no files go inactive and fall between the tracks, and file cost warnings. These are some of the things we're going to start by having a look at. So I'm going to switch out of PowerPoint and take us to Amicus Attorney. Hopefully everyone's aware of what Amicus Attorney is. It's the world's leading practice management software for lawyers, and you could think of it as a law office on computer or a lawyer's desktop. It incorporates a wide range of different things that you need to work with and types of information brought together on the professional side of your practice. It also handles the billing side as well, so I can be looking at my practice from the billing side and do trust management and other things like that, or I can be looking at it on the professional side. We're going to focus today on the professional side, and again, I'm not here to give you a tour of all of Amicus Attorney. I want to talk about just some specific features that reduce your risk of malpractice. So if I want to see my list of client matter files, I just click on the Files tab, and here are all the files I'm working on right now. If it's a WidgetCo share purchase matter I want to see, I double click, and here is all the information relating to WidgetCo. So the first important concept here is that all of my information is electronically in this file. You can see it's everything from status reports to notes, all the events on the file, anything on anyone in my firm's calendar, the time, all communications, all emails on the file, documents, the legal research. I can see a chronology, plus custom pages, so any and all specific types of information relating to this particular matter. It's a share purchase transaction, so for instance, the registered corporate name, officers, board of directors information, common share information. If it was a litigation file, this would be totally different information. It's all here in one place. Some great advantages from a malpractice point of view. It's always consistent, so when someone in your firm learns of a change to a piece of information or gathers a piece of information, it's put here and everyone has it instantly. It's always available, so if your assistant is working with the file and has it on her desk and you suddenly have to answer a phone call about it, you have it right there. You have the capability of making types of information within this file mandatory. In other words, you can't even open the file without tracking that information, which means you can't overlook anything as you're setting up a matter. And you can even have file information put in by the client. Remember that point. I'm going to come back to it in a few minutes. All your documents are always here, and this is just fantastic. So again, remember, one of the malpractice claim reasons is documents get lost or overlooked. But all of my documents on this matter are here. So if I want to see that subscription agreement, I can just select it and I can say turn on a preview, select any given document, and the whole document is right here for me to review. And of course I can then open it in Microsoft Word or Excel or whatever format the document's in, edit it and everything else, but I don't even have to do that. I've got all my information right here. And again, even if my colleague, my partner is also working on this matter and has a file, I've got the documents at my fingertips. Now, one of the other areas that give rise to malpractice claims is in tasks and delegated tasks. So I can go on my file and see everything I have to do on this file. You can see we've got a closing coming up for this transaction. It's on May 17th. But I'm not the only one working on the file. I've delegated some tasks, and very often failure to follow up on delegated tasks gives rise to a malpractice claim. But look, with Amicus, all I have to do is go to all file events. Now I'm seeing not just my own events, but I'm seeing everything everyone else has to do. So their initials, their role, senior partner, assistant, or whatever is visible for me right here. And I can see what's been done and what hasn't been done on the matter and make sure it's all going to be done by the time I need to. But let's go make this a little simpler and go back to my list, and we'll sort it by date, and I've got this closing coming up. Here's another thing that's tremendously helpful, and that is that I can link tasks together so that they're all scheduled properly. And remember, one of the other critical causes of malpractice claims is that calendared tasks are missed or calendared incorrectly. So what I can do, for example, is say that with the closing on May 17th, I want to start getting ready for it on May 10th, a week ahead of time, and I want a deadline the day before because I can't possibly go past May 16th without being ready for this closing. They're all linked together. Plus, really importantly, report to client on closing. Remember, we said one of the other principal causes of malpractice claims is failing to report to your client. So I can schedule that. Now, what's going to happen? Well, the other side is going to phone up and reschedule this closing, as so often happens. So if we double click on this, we're talking to the other side and they say, you know what, we can't do it on the 17th, let's do it on the 25th. So watch these dates on the list when I say okay to that rescheduling. It happens so fast. Look, the report to client is now scheduled for May 26th, prepare starts May 16th, deadline the day before, the 24th. So by linking those tasks together, you do two things. One, you ensure that everything is properly scheduled, and two, you ensure that you can save related tasks together like this and not overlook anything. Well, it gets better than that because I can now say, you know what, I do a lot of closings, and having set this up once, I just want to be able to reuse that. And maybe next time I'm going to delegate this closing to my junior, but I want to make sure my junior never forgets to do any of those steps. Back to that malpractice claim for delegation issue. So I can select that closing and say, save this as a precedent. And all I do is give it a title like sample closing for demo, and I'll say okay to that. and it's going to prompt me and say, you've selected an event that's linked to one or more others. Do you want to include all of them in your precedent? Yes, of course I do. The report to client, everything that's really important. So I'll say yes to that. And now it's giving me a chance to put in some notes to say who it's of interest to. I could put it to a work group in my firm. I could edit it, but really all I want to do is just save it and say thank you very much. Now then, let's close this file and let's go to another file. We're going to open a real estate file that we've just opened. It's a blank purchase from Biddle file. And because I've just opened it, there's nothing scheduled on it yet. Remember, we said that real estate files are actually the #1 practice area in which malpractice claims arise. So we'll go to our events. It's blank. Nothing's been scheduled on this matter yet. But I have a precedent for malpractice claims, so I'm going to say use precedent, residential real estate purchase. Thank you. I'll say okay to that, and well, when's the closing? Well, our client's given us a couple months notice. The closing is going to be on June 22nd. Say okay to that. It'll spin for just a moment, and what it's going to do then is schedule all the related steps. There they are. Again, I'll sort by date just to make it a little simpler for you. You can see the closing is on June 22nd. All of the steps ranging from reviewing the agreement of purchase and sale, the requisitions, meetings, and critically again, report to the client. They're all scheduled for me. Now that was a very, very simple example. I'm sure that your checklists for a residential real estate case are much more comprehensive. The great news is instead of having those on a piece of paper that you staple to the inside jacket of a paper file, you have it electronically like this. You can delegate the tasks to the paralegals or whoever's responsible in your firm, and you as the lawyer responsible can have confidence that all the necessary steps are always being scheduled, always in the right person's calendar, and always being done, thus significantly reducing your risk of malpractice claims. So another area that comes up in malpractice claims around matter management and tracking is inactivity. You know, we talked about files falling between the cracks. You open a file, you start working on it, you're waiting to hear from the other side, and it goes into limbo. You have a trial or something else coming up, you get really busy, and then you just lose track of that matter. So again, practice management software like Amicus Attorney can do great things for you here, because if I go in to the administration section of this file, I can say, warn responsible lawyer if no time entry, you pick your period that it can stay dormant, 30 days, 60 days, whatever time period you set there, if work's happening regularly on this file, time entries will be going in. But the minute a file doesn't have any time entries for the period you specify, a task is going to be automatically put on your to-do list that day telling you to check out this file and make sure all's well. Another area where clients come after lawyers for is with respect to fees. If you tell the client, well, you know, my hourly rate's $200 an hour and this isn't going to take cost more than $2,000, you know, about 10 hours. And then, of course, you send them the bill for $5,000. They get pretty upset. And if you subtracted that money from a trust fund or a retainer balance when you were dispersing funds, they get really upset and oops, you've got a claim. So simple checkbox removes that as a possibility. Just set the total time being no more than 10 hours and bang, you're going to get a warning if you go up for it, because practice experience shows that if clients are warned when you approach the estimate you gave them and tell them actually we're going over time and here's why, then the client stays happy, and a happy client does not sue for malpractice. So let's talk about some more related calendaring activities. For example, here I'm in the Amicus Attorney calendar, and it's a great calendar for we attorneys because it's like a lawyer's daybook. It does everything Outlook does, of course. In fact, it synchronizes with Outlook, so anything you put in your Amicus calendar is automatically in your Outlook and that smartphone and everything else. But it does so much more that Outlook simply can't get a concept of. And we're talking about deadline management. So let's have a look at my to-do list here. Here's my appointments for today, pretty open day, and here's the tasks I've got to do. I'm a litigator, so I've got to prepare a cross-examination it's turned it red because it's due today, and it's telling me in plain English, due today. And there's a bunch of other places in Amicus Attorney that when I start up, it's going to be warning me of the deadline for preparing this cross is today. I can see the file it's on if I want to. I'm warned that I've got to complete this task today. Then the next task on my list is due on May 10th. So it's counting down for me. It's telling me I've got 13 days left. So I call that my panic factor. How long until I have to panic about this one? The point in terms of malpractice is, of course, it's giving you a clear countdown so that you know how big is that share purchase agreement that I'm going to have to work on. How long do I have to spend on it? I've only got 13 days. I'd better get working on it. And as these things come up, you get a daily report. So actually, when I first come in the morning, this dailies, we call it, shows up on my screen. And let's have a look. It's going to be different every day depending on what's happening in your practice. So some of the items on my to-do list are getting rather stale. Now that's another issue. Remember, one of the items on our list for reasons for malpractice claims are procrastination. So if we go into our calendar, we've got something 136 days on our list. That's procrastination. It shouldn't be happening, so Amicus Attorney warns me about it the minute I get into the office. And these are hyperlinks. They'll take me right to the events that they're speaking of. Also, that I have deadlines today, so I know coming in I've got to do these things. All right, notice this next one. On the Aladdin purchase matter, I've already spent more than 12 hours, so that check box must have been set on that file, and I'm getting a warning, so there's more help with it. And of course, it's going to give me some help with time entries and other such important things to my practice. So that's great. One of the other principal areas, in fact, the number one area for malpractice claims revolves around client communications. We've talked about how reporting to clients is a major area where attorneys tend to fall down, and we've seen how you can automate reminders to report to the clients. Another area is instructions or information. Did you inform your client that the following was happening? What did they say? Did they give you instructions? What were those instructions? Did you follow them? Those are principal reasons for malpractice claims, in fact, almost the number one. And often in today's world, those things happen in either emails or phone calls. If they're in emails, Amicus Attorney automatically saves all emails to and from your client that you send in your Outlook into the Client Matters file for you without you having to do more. So you can't lose them, and those facts are recorded. Phone calls are, of course, a little trickier, but Amicus Attorney really helps too. See, we've got to call Janet Bailey, who's our client on the Bailey Reed-Kipling matter. All I have to do is click this Do button, and an attendance note comes up for me, already filled in. Who did I call? What number did I dial? If I had the Windows dialer connected, it even dialed the call. Who am I? Heather Gavel, the matter I'm working on. It's got a timer running, and I can now keep notes about the call. Yes, you can dictate into that if you have Dragon Dictate or something else. While I'm talking to the client, I can see my entire call history of previous calls with this person. So if there's any discussion or concern as to what was previously said, I can see them right here. I can make my notes, and you all know how important that is, because if later on the client says, you didn't tell me about this, and you say, yes, I did, in a credibility dispute like that, the client's version is almost always going to be preferred. That's why it's so important for us to keep attendance notes of what we're being told and what we're telling our client every time. Keeping those notes and keeping them in a form that survives, 3 years from now before suddenly that claim becomes relevant. This makes it so easy to do. And of course to follow up with a time entry after the fact. So those are great. Another important area is just keeping in touch with your clients, sort of like the file, but a little different in terms of people. So if I've got a client and I want to deal with them, I need to know when I last kept in touch with them. And that's why Amicus Attorney has a last contacted date. So if we open up, here's a client, Jonathan Fly, we open it up, here's his contact record. We last contacted him on January 13th. How does Amicus know that? Well, of course, you could just put in that date by clicking the little selector here, but that's the hardest way to do it, because Amicus Attorney is, as we said, tracking your email. It's tracking your phone calls. It's tracking your appointments and tasks and other things. So if you ever anything that communicates with Jonathan Fly, Amicus Attorney knows. If you send an email on your cell phone, Amicus Attorney knows and will automatically update that date to the date you sent that email to them. And therefore, it's going to know who you've been in touch with. And if you check this box, remind me to keep in touch with this person you pick the number of days, say 60 days for Jonathan, then it will put reminders on that daily report we saw and a task on your to-do list to keep in touch with that client. And that's so powerful in terms of avoiding malpractice claims that arise out of failing to keep in touch. All right, the best way to keep in touch and to collaborate with your clients and to ensure all their instructions are being followed and that you have all the right information from them is to let them put it in themselves. And that's why Amicus Attorney has a secure client portal. So here I've logged in with Google Chrome, and now I'm logging in as a client of my firm, Gary Burwood. And there's my firm name and logo, so it's branded for my law firm. But I've logged in as Gary, who's not a lawyer. I'm now a client. And as a client, I can go in, see all my active files or documents or exchange secure notes with my attorney, or open up a file, see all the documents, do a file intake, exchange information with my attorney. If I send my attorney, say, a comment on an affidavit in a note, I can just open this document and say, you know what, I want to add a note to that. We'll send a little note about the affidavit, and we're sending that to Heather Gabel, our attorney. And you can see down here flashing, of course, I'm cheating a little bit here because I'm running both Amicus Attorney as the attorney and I've logged in as Chroma as the client, but you get the impact. It's instant, real-time, 256-bit encrypted information going to the attorney from the client. So you get the track record of what's been said, it's secure, and you're collaborating with your client. You're keeping in touch with your client and avoiding those malpractice claims. All right, another big area, we said it's 7 or 8% still, is conflict of interest searches. So of course, Amicus Attorney is great at doing that for you. Now, a lot of people, believe it or not, either conflict search is scratching their head and saying, I don't remember dealing with this person, or they go to their accounting system. They go to something like TimeSlips or QuickBooks or something, and they do a search there to see if there's a conflict. Well, the problem with that is accounting systems only keep information about your clients. By the time somebody was formally a client paying you bills and entering into your accounting system, clearly acting against them is going to raise a potential conflict. Or not necessarily, but it's much higher likelihood. But there are so many other ways in which a conflict can arise. So Amicus Attorney is so powerful on that. If we want to search to see if somebody named Firth or, I don't know, somebody named Smith has been a client or there's a possible conflict with them, yes, all the contact names and so on can go in, or not they were a client. But also things like, did they show up in a custom text field on a file? Is their name in a document? Did I do a time entry relating to them? Did they send me an email? So if somebody sent you an email and they laid out the facts of a situation that arose and consulted you about a possible retainer, you didn't get retained, therefore they're not a client. They won't show up in your accounting search, but there's a real potential for a conflict of interest. This will catch it. Or even if their name showed up in the body of an email. So then we click check, and that fast, look at all the different kinds of information, couple of documents and so on relating to Smith. Now, there aren't necessarily conflicts for all of this, but it's a much more comprehensive, in fact, it's the most comprehensive conflict of interest search you can do in any software for attorneys anywhere. And that's how you avoid conflict of interest searches. Now, there's a full library for collecting information on legal research and so on, but of course, while that's just putting information at your fingertips, it's not necessarily doing the legal thinking. I mean, the good news is that it's still up to you to do the legal thinking and come to the legal judgments. Can't help you there, other than that with all of the automation of the process of practicing law, you're saving time. In fact, our clients in a recent survey told us that they save a little over 8 hours every week of administrative time per person thanks to using Amicus Attorney. And that saved administrative time gives you more time to focus on what's really important, like the law, so that you can hopefully do a little bit better job on all of that. Right, now, lastly, what I want to show you is a file intake process, because a lot of this comes together when you open a new file. We talked about the importance of tracking information, recording limitation periods, and so on. So if I want to open a new file, do I want to create one on the current file? No, I'll create a completely blank one. So we'll just call this sample file, and the client is going to be John Smith. And okay, it's a civil litigation file. So it's a simple file intake form, correct? It's a lot more than that. First of all, notice that some of these fields have an asterisk beside them. Wherever you see the asterisk, it's mandatory that that information get filled in. And you as the attorney, in setting up your Amicus Attorney, can determine what you want to make mandatory, because it's not usually you who opens a file, it's your assistant or paralegal or someone. And here's the information you want to make absolutely mandatory before the file can get opened. And when you set the file type, you also set what's going to happen when they click next. Please select the primary client for the file. Oh, I forgot to select a client. We'll do it with Janet Bailey. Now notice, it's civil litigation, so the next page is information about the file. And all of this information is relating to civil litigation, the amount claimed, date action commenced, court action number, title of proceeding, all of this. Again, you can make any or all of this information mandatory. So these are custom fields you describe. It's up to you. What do you want to make sure is collected? It would be totally different for real estate than litigation. And this is going to be, I don't know, a wrongful dismissal case. And that, of course, is going to guide some of what happens next, too. Now, this is just a simple form. We could have gone on for several pages in terms of this, making sure the right stuff happens. Did we open the file? Not quite. Look what happened next. It's telling me to check conflicts. Again, there's that asterisk. It will not open the file without me checking the conflicts. So there's Janet Bailey. Those boxes are checked the way we did last time. You can change it if you want. There's all the possible conflicts with Janet Bailey. She's an existing contact, of course, because she was a client, but there's a file with her. There were emails to her, phone calls with her. I can review any of these things if I want to see that phone call. Just double-click on it, and I can see what was said about Janet Bailey there. So I've done a conflict search. Look at this one, apply precedent. It's a litigation matter. I need a limitation period. Who's going to be responsible? Me. When is the limitation period expiring? Well, we'll go out and say it's in 2019, November 20th, whatever that may be. It's now applied that precedent. Last but certainly not least, and again, here's an area where malpractice claims arise, failure to obtain a proper retainer and engagement letter. So we're going to generate that just by clicking on that. It launches Microsoft Word, and up will pop on my screen a complete engagement letter. That took just a few seconds, and it's offering to save it back into my Amicus. Let's have a look at this letter. I'm in Word. Remember we called it our sample file. It's addressed it to Janet. What date did we open the file? What's our file reference number? How much do we want on retainer? And there's the formal retainer document. So it did a letter, an engagement letter, and a retainer in a matter of a few seconds, and it saved it back into my document management system, so it's on the file, and it did that with one click before I even opened the file. I won't bother saving it, and now we're done. We can put in our file summary or whatever else. If we want to go in and see the events, there's all those limitation period reminders. So you can see my precedent happens to go from it's about to expire 1 week away to 1 month, 6 months, and a year away. You can have whatever reminders you want, or other types of precedents. That real estate, if it was a real estate file we were opening, that residential real estate precedent could have been all applied. That ensures everything necessary is done, every deadline is tracked, and your risk of malpractice claims is significantly reduced. All right, so I'll go back to PowerPoint and just quickly summarize. Here's what we've just seen in Amicus Attorney. You've reduced your risk in tracking critical information on files and documents, inactivity, and cost. You've reduced your risk with great legal-specific calendaring, true deadline management, linked events, automated court docketing is available to you, adjournments are automatically tracked, and all those daily reminders we saw in the daily report. You've reduced your risk in that huge area. The #1 malpractice area is communications with your client. You've got automated attendance notes. You've saved emails to files automatically. You've got automated reminders to report to your client along the way, to keep in touch with clients, and the client portal, which is simply phenomenal for tracking all client activity and for sharing information with your client. You've reduced your risk with conflict of interest searches in a way far beyond anything that an accounting system could do. You've reduced your risk by having more time for thinking about the law. And we've seen how a simple thing like a file opening or file intake process can be so automated that all the necessary steps are taken, the conflict's done, the engagement letter is created, limitations are diarized, and everything you want to have collected can be made mandatory to collect. So with all of that, it is no surprise, I'm sure, that many malpractice insurers will actually give you a premium reduction for using practice management software like Amicus Attorney. The amount of that depends on the insurer, and it may be, of course, that you're already using a series of automated systems, so they won't give you even more, but most malpractice insurers will give you that reduction, and that reduction alone is often more than enough to pay for the software. If you want to find out more about Amicus Attorney, please do contact us. Our website's amicusattorney.com. We offer free trials, and of course there's a cloud. I've been showing you, I should point this out, I've been showing you the desktop version, but there's also a full cloud version, Amicus Cloud. So everything I've shown you today can be done in a full cloud version in your browser as well. If there's something I've said you want to follow up with me about, please by all means do. There's my email address. I'd be delighted to talk to you about anything we've covered. Thank you so much.